Hey, good morning, everyone. Welcome back to Law and Legitimacy. We weren't around much last week, and that's because I was on trial in Stamford. That's just next to New York City. It's the one place in Connecticut that is almost impossible to get to because traffic is so thick. Welcome. Good to see you again, Mike. How are things in North Carolina?
They be hot, boy. It is cooking down here. I had a thought over the weekend, Norm, because I was chasing a few with my son. Do they have lightning bugs up in Connecticut?
They do. We do. Yes.
I didn't. I just wanted to make sure that wasn't something that we were, blessed with. Yet another feature of the center of the universe that the rest of the world had to go without.
Oh,
But
no.
yeah,
No, no.
lightning bugs and lightning bugs are out really early, which is kind of funny to see. But it's getting real hot here.
Well, it's pretty warm up here. I mean, I can tell you that much. We had massive thunderstorms last night, knocked out power for a lot of the state. Fortunately, our generator, for whom we are not being paid advertising dollars, is kicked in and working. So we're grateful. The trial didn't work out. We now have a new law in Connecticut. Spite lights can get you accused of violating a criminal protective order. Our client was a guy in his 40s. He had a dispute with his elderly neighbor, and he bought stadium lights, strobe lights, and everything, and shown them at her home, in the direction of her home. And the state got so upset with him, they charged him with a crime. We tried to argue that there was that didn't fit the meaning of harassment or annoyance or alarm within either the breach of peace statute or the criminal protective order statute. The court held that it did as a matter of law. The client was convicted. There were a lot of lights. And so off we go to the appellate court. So lest you think it's all murder, storm, and stress here, sometimes we get involved in neighborhood disputes. It was a long and bitter trial, and it's difficult, to cross-examine a sweet 86-year-old woman about how uncomfortable she is in her own living room, but I survived it. In today's mail, however, this comes from somebody who is calling himself Ramrod from Truth Justice Road in New Haven. Hey, Norm, you say Trump or anyone shouldn't call judges names, right? You said you never did. But put yourself in Trump's or Alex Jones's shoes. How would you feel if you were getting fist bleeped by the judge and his corrupt court? I'm sure you'd be mad as hell what they were doing to you. Trump's cases are an old style, Soviet style of justice, and Trump knows it and he fights back. So until you put yourself in his shoes with this bootleg charges and this corrupt judge, you don't know what you would say. Well, maybe. Although I do know this, that when I thought unjustly suspended from the practice of law for 6 months by the judge in the Alex Jones case, I don't think I turned around and called her names. I think I did make some tart expressions about her judgment, and maybe I was over the line. And this morning, in fact, when we got that overturned by the appellate court, it was remanded for further proceedings, and one of the lawyers in my office will be at a status conference this morning to figure out what happens next. So, I hear you, Ramrod. I think he's responding to a piece I wrote for Hearst Media. I'm starting to write columns again. There'll probably be another one in the Hartford Courant this week. I like the written form, and I'm back at it. So what's new in your world, Mike? What catches your eye?
Well, a lot. Work is very busy. It's a very busy season. Clients that are, sort of opening, new openings over the weekend, and then big closings on tap for this week. So I'm also starting to pay attention a little more to we've got a lot of beverage alcohol work, and I think it's funny for me to even say that, but right, everything comes in cycles and everything comes in waves. I think you would know that as, a criminal defense attorney. I'm sure that there are things that you like working on more than other things, and then you have these undulations of when you have a high volume of that sort of work versus not. And we're certainly hitting a peak in the demand for what we do on the beverage alcohol side, but it's because of the pressure that hemp is putting on the industry right now from a beverage perspective. Everybody is looking to try and figure out how to incorporate this Delta-9 hemp-derived Delta-9 THC into a beverage format, and there's simply no federal or state regulatory frameworks that pave the way for that. And we're talking about food. So lots in that realm, and then perhaps even more on the law enforcement front, but more to come on that. But busy, 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 loving that. Just trying to stay a little bit sane.
So what in the world was going on at the Travelers Championship this weekend? I'm not a golf watcher. Every time I watch it, I just want to start mocking the announcer. And now we woke up to the 18th hole. It's final, pivotal round. Blah 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 blah. But I mean, apparently we had protesters on the green at the final hole of the PGA tournament.
Yeah. So you sent me this. You sent me this story, and I had no idea this happened, but
I figured you'd be watching the tournament,
because our boy Scotty Too Hottie was on the green when it happened, right? So it happened on the 18th hole, and this was the culmination of the Travelers Championship. Scotty was nursing a lead, and he ended up having to go into a playoff round after this. But on the 18th hole, members of what's called Extinction Rebellion, Norm, took to they had those little smoke bombs and they started running all over the green. You start seeing people getting tackled and arrested. And you dive into the story a bit, Norm, and we learned that did you catch why they were there in particular? Like what about the climate they were protesting?
No, I didn't. No.
So apparently, it says here, Extinction Rebellion took credit for the protest, citing a lightning strike that injured 2 fans during Saturday's round at Travelers as an example of, quote, increasingly unpredictable and extreme weather conditions.
Yeah, well,
No golf on a dead planet.
All right. Well, there's a breach of peace waiting to happen. So,
yeah. So I mean, what is it? What we got? Assuming that they're there lawfully, right? That they're even there as an invitee, right? Or a licensee, we'll call it, because a ticket is a license. Many people aren't aware of the underlying contract to sporting events. If you turn over your ticket and look at the fine print, it's not some sort of unfettered or unrestrained right to be somewhere. It is a revocable license. So assuming that they're there, this is a one of the more caustic examples of a license revocation that you will ever see. So from a legal perspective, just to put some punctuation on that, assuming they're lawfully there, if they're not lawfully there as an invitee by way of a license, then they are trespassers, and they will be.
Here's an interesting question. Once the license is revoked, are they trespassers at the moment of revocation?
Correct. Yes. And typically with the way the law treats it is that if you're a licensee, your license is revoked. The invitee or the invitor, the premises owner, or whoever manages it, will give you a quick and easy exit, but allow you to actually vacate the premise. But to the extent you do not indulge or oblige that revocation, you then turn into a trespasser almost instantaneously from a legal perspective.
And can they be charged with breach of peace, or criminal mischief?
I'm sure that they can at that point. Once you become a trespasser within that legal definition, my assumption, Norm, and I would defer to you for this, but from a criminal perspective, that's no different from the sort of that toolbox of civil remedies that would be available to a claimant or a plaintiff. The same would be available to the state or a host that wanted to press charges criminally.
Well, before we turn to the big decisions that the Supreme Court's likely to announce this week, I want to turn attention to a California case that caught my eye. California, man charged for driving family off 250-foot cliff granted mental health diversion by court. How does society best account for a broken mind? I recommend everybody read the piece, because when I first read it, I kind of scoffed. I mean, really? You're driving your car with your family off a 250-foot cliff and you're getting a diversionary program. And then when I read into the story, I thought, this was a sort of nuanced mental health approach to a problem that I wish the courts would consider more often. Apparently, the driver suffered from serious depression and maybe bipolar or schizoaffective disorder. He's got his family in the car. And he drives it off the cliff. Now, I gather everybody survived, which is a near miracle. And I wonder whether the result would be different if anybody had died. But, it is, as a criminal defense lawyer, the there's the dirty secret of criminal defense is that criminal defense can only deal with the most obvious mental illnesses in a principled way. What do I mean by that? If a person is insane, that is, they lack the ability to discern reality. The classic example is somebody stabbing what he thinks to be a bag of potatoes. It turns out to be a person. That's an example of cognitive insanity. The more typical form of insanity is your inability to control your impulses. You just can't control your conduct within the requirements of law, and therefore you can't be held accountable for what you can't control. In extreme cases, those are easy to see. At another end of the spectrum, there are the so-called competency cases. A person charged with a crime appears in court, but to his lawyer and to the court appears unable to understand the nature of the proceedings against him or to assist in his own defense. Due process requires that a person be able to do both. And so, in a criminal defense lawyer's life, there'll be a few times a year where you make a motion to have your client evaluated for competency. Now, the standard for competency is very, very low. When you read a competency report, you're thinking, who did they send the postman in to do this? Do you know what's your lawyer's job? To defend me? What's the prosecutor's job? To try to lock me up? What's the judge's job? To help me get a fair trial? What are you accused of doing? I'm accused of killing somebody. That's about all it takes to be found competent. Where things get very difficult is when it comes to the ability to assist in your own defense. It's one thing to understand the nature of the proceedings against you, and to understand the role of the participants in the proceeding against you. But some clients really are incapable of assisting in their own defense. I'm aware of a case where a young person will not communicate with his lawyer or his lawyers. And at some point, that law firm is likely to have to file a competency motion, because how do you prepare for trial if the client won't talk to the lawyer? Is the client suffering a major depressive episode? Who knows? That's what psychiatrists are for. So those are easier cases to deal with than cases like this. A guy drives his car in an apparently suicidal, homicidal way. I've got to believe that if you're driving your car off a 250-foot cliff, you're surprised that you lived when you get to the bottom of it, even if you are in one of Elon Musk's Teslas. So the court's decision, the lawyer's decision to have the man's mental health evaluated, and the court's decision to give the man a mental health diversion, I think is really courageous on the part of the judge. I can imagine a lot of people saying, this guy should be locked up. He's a danger to society. And in the story itself, you'll see some critics of the decision saying the man can hide his mental illness really well. How do we know he won't do this again? And my sense is, if we're going to take mental illness seriously, if we're going to take the notion that sometimes people go off the rails in uncharacteristic ways that are a sign of illness, and that illness can be treated and controlled, a mental health diversion might be the appropriate outcome. The states are often reluctant to want to do this because they're afraid that the next time down the line they'll be blamed for giving someone leniency. I remember a very infamous case in Connecticut that my former partner John Williams and I were involved in, I think in the 1990s, when Prozac was new on the market. And I think I've talked about this case on this show before. Our client was given an overprescription of Prozac, and the result was a manic episode. He began to act in ways that were not characteristic of him, and he engaged in a series of bank robberies. So we had him evaluated by psychiatrists who concluded that but for the overprescription of Prozac, he would not have engaged in this conduct, and therefore, as a result of the Prozac, he was not guilty by reason of insanity. The state was outraged by the suggestion that an overprescription of a regulated drug could produce a result like that. So they had the guy evaluated as well. And when their psychiatrist came to the same conclusion, the result was foregone, was foreordained. He was adjudicated not guilty by reason of insanity and remanded to a psychiatric facility. As luck would have it, he remains there now, 25 years later, just because he can't comply with the conditions of his release whenever he's released. We often wonder whether he would have been better off just taking the 9 years that he was offered for the bank robbery on a straight plea. So mental health issues are very, very difficult. The law talks about people bargaining in the law's shadow and making cost benefit decisions as rational actors in every decision they make. Experienced criminal defense lawyers know a far darker truth, and that is the most significant shadows cast in a courtroom often come from within the client, and mental illness accounts for them. So I commend this decision to you to read about, to think about, and to talk about in your own communities, because I do think that mental health drives a significant percentage of the business in criminal courts.
Well, I have thoughts here. Number one, the children were 8 and 5, or are 8 and 5. Daughter 8, 5. Son is 5. So the picture I have on the screen here is obviously a few years older. It's taken from Facebook as part of the article. But the wife is one of the individuals that was, I guess, advocating and pleading with the court to allow for the mental health diversion. Um, I, I wonder. I wonder if there were any deaths associated with this, whether we would be having a different conversation, Norm. And I'm not sure that that's being fully captured. What I can tell you though is that at 8 years old and 5 years old, these children are not going to forget that experience. And we have a situation where a father, right, uh, patriarch within the household, has created a memory that all four of them will experience differently for the rest of their natural lives. And so I think the criminal process is isolated to the individual. This is something I've felt for a long time, that the criminal system cannot effectively adjudicate an issue unto that family, right?
True.
And that really is that's something that I don't have an answer for. I don't even necessarily even know where to go with that, other than the fact that I do consider um, the, the memories that are now forged in fire, but with the children and how they will view their father here and after. I think it was in this article reported that he suffers from schizoaffective disorder, and I think that more broadly in America, we've been talking about a sort of a mental health crisis of sorts in the decades following a move from the institutions, right? A move away from institutions of yore. And so these sorts of things are just, I think that it's also fortunate that nobody else was involved. No other family, nobody else on the road was involved with this as well. So curious
No, I hear
case,
you. I hear
curious,
you.
very complicated.
It is complicated, and had someone died, the results likely would have been different. Had third parties, had he collided with another car and caused serious injury to a third party outside of his family, I think the result would have been different. But I wonder whether it should have been, because I'm a criminal defense lawyer. I go to court most days, and a significant number of those days, I'm standing next to a client who is not bargaining within the law's shadows. I mean, they're suffering from some sort of mental health problem, and the criminal justice system is locking them up to protect society, and not really offering them the rehabilitation that they need and they require. And it's a blunt instrument. And so I think that in terms of a broader utility, protecting society, that points in the direction of locking someone up. In terms of individual justice, if we can't provide treatment to the ill, it seems tragic that we lock them up to protect one another. But
Well,
that's
that is really interesting, right? And sorry to keep this going a little longer, but what I question whether his intent was, well, obviously, I think his intent can be fairly inferred by driving off a 250-foot cliff. So don't get me wrong there. I'm not trying to miss the forest for the trees. But if we're talking about an acute psychiatric break versus some sort of sincerely held belief, whatever. I mean, this was driving off a cliff reasonably calculated to do the job that you wanted to do, right?
Yeah.
And to that end, this whole case is very curious because now if you're his wife, and people are saying that he's able to hide, this article reports that, there are allegations that he's able to hide his mental health issues, this, that, and the third. I mean, do you not feel as his spouse that he has made his intent clear? Right?
Yeah.
In some corner of his mind.
And when's he going to do it again? I don't know. It's a horrible case. I mean, as so many criminal cases are. Hey, where do you want to go next? I know you're hot to talk about the Connecticut Bar Association's message. I was interested in Supreme Court cases.
Yeah, let's do Supreme Court. I mean, I got a chance to talk about the Bar Association stuff on Friday on Laid Back, and I do want to get there. I think we will get there. There really isn't a rush for that, I'll say. But I do think that with so much coming this week on the Supreme Court docket that we should at least hit this and highlight the cases that we have from this article in The Hill.
So The Hill reports that there are 5 major decisions to come from the United States Supreme Court, and most of them will likely come this week. I believe the term ends at the end of the month. The first is do presidents have criminal immunity for official acts while in the White House? What's your prediction? How's the court going to vote on that, Mike?
That's a pretty big one, right?
Yeah,
pretty big one, because if we talk about January 6th, he was still in the White House, right? So I would assume that I don't know. I think that they are going to uphold the standard of barring, criminal liability for acts while in the White House. But
yeah,
I think that my question is, how are they going to dance around? Because there's an interest in more than just Trump with that. I think that the groundswell of criticism for the Obama administration has become almost intolerable, right? But the criticism of the Obama administration is necessarily his use of drone warfare and American citizens that were killed abroad through strikes that he authorized militarily, and whether he should be criminally prosecuted for his role in that, right? Now, I'm not saying that those are apples to apples, but certainly presidents have long benefited from total immunity from prosecution for acts while they're in that seat as the chief executive. So I think that they're gonna. To me, this is an easy. If you want to qualify as a Trump win or not, this should be a fairly straightforward Trump win, quote unquote.
Yeah, I'm going to call this one 5-4, maybe in favor of Trump, and I think the justification will be that there's an impeachment remedy for high crimes and misdemeanors for a president sitting in office, and that is part of his political judgment. He's going to make close calls, and the decision to prosecute shouldn't belong to one branch of government, but it shouldn't belong to the executive branch, but should belong to the legislative branch, which has the ability to impeach. So I'm going to predict, going out on a limb, I'm going to say 5-4 or 6-3 in favor of immunity. January 6th obstruction charges. That's the 18 USC 1512.
Here's the one.
That I got to give Nick Smith of the Proud Boys group credit for this. He perfected this issue, and his team's petition was heard, not the petition that we filed on behalf of Jake Lang. I don't know what to think about this. When I look at the statute on its face, it says, that it's an Enron statute that provides that people who engage in obstruction of official proceedings should get up to 20 years. And typically that involves tampering with evidence. The statute was amended to say, however, or otherwise engages in obstruction. So I think a lot's going to depend on how the court applies the rules of statutory construction. On its face, I think the statute applies to the J6 cases. It's gone up through the D.C. Circuit. There was a 2-1 decision with no one set of rationale controlling. I don't know. I candidly, Mike, I don't know what I think this. I don't know. I can see this one going either way. I can tell you that if it goes in the direction of saying that statute cannot be applied to a riot, there'll be a lot of resentencings in the January 6th world, including the Proud Boys. However, none of the Proud Boys are likely to benefit because the sentences that they were imposed on them for the 1512 charges ran concurrent with other charges that aren't going to be challenged. So they'll be resentenced to the same time. So I'm not going to make a prediction on that one. That one, in my mind, is too close to call. You, Mike?
I think it's probably well. The genesis of the statute being an Enron statute means that we're talking about white collar transactional crime primarily. That was the impetus, the spirit of the law. For the Justice Department to take that very broad or otherwise engages in obstruction and then apply it in a very physical nature, a very physical, like sort of rote level, almost id level to physical conduct of people, to me is an abstraction of that law. And I think that the Supreme Court should have no trouble tracing the lineage of that statutory framework and then making it obvious that was something that was never contemplated by Congress at the time it was used. And if there are issues related to conspiracy, trespass, violence, that there are plenty of other mechanisms by which the federal government could bring charges against people.
All right. So what's your prediction on the vote?
I think probably 5-4.
Okay, another close call.
In favor of Fisher.
Third issue rather. Did the Biden administration coerce social media companies to remove false or misleading content in violation of the United States Constitution? And I think this is an easy one. I think this should go, 8190. I don't think the Biden administration has any role in policing what gets put on social media. The administration tried to curb misinformation in the wake of the 2020 election and COVID-19 pandemic to support administration points of view of what was in the public interest. I think this is a slam dunk for the First Amendment. You?
I agree. And I think that, the question that I have following the presumptive outcome here is, what the hell does it matter?
Meaning?
Meaning, how are we to redress the clear excesses of government based on that conduct? Because that's the real impetus behind Trump and his populism right now is that, right? Is this sort of this, again, I don't want to, this perversion of authority and institutional good name, and then using it for purposes that become clearly, I don't want to just use the C word, corrupt, but become clearly antithetical to the interests of liberty and due process and civil rights. And it's, this administration has kind of been, they're synonymous with just a sort of a collective shrug when it comes to that kind of stuff. In my opinion, it's just like, okay, whatever. Right.
Florida, Texas, another flip side of a social media decision. In this case, can the government tell social media platforms how to moderate content without running afoul of the First Amendment? It may sound like the same issue, but it's not, because what it basically says is efforts to prevent social media platforms from banning users for their political views are prohibited. So it's a similar issue, I suppose, to the Biden social media content issue. I expect that once again, the states will be slapped down and they'll be told that they cannot prevent people from appearing on social media basically because of their views.
I think we generally agree here. Here's something to watch for that comes out of this, depending on the outcome, Norm, is what that means for anonymity online.
Interesting. Yeah, I'm not in favor of anonymity online. I think if you say it, if you say it, you should own it. And I understand that there's a long tradition of pseudonymous writing in the United States. Indeed, the Federalist Papers were largely written pseudonymously. But if you want to make people more accountable for what they say, make them put their name on it. And that doesn't seem to me to be the end of the world.
Well, and that's what X has done. In the private market, what X has done is turn premium versus non-premium into that sort of verification, and to take away really from, it's not really anonymity for anonymity's sake. If you don't want to be who you are, you can't just simply change that and still have access and and sort of the influence that you would traditionally have without going through some sort of review, right? So the paywall is what has changed that for X. I think that's the model. But I am thinking about the Nikki Haley's of the world that we're saying, that everybody needs to be authenticated or registered online. And to me, that runs afoul of the First Amendment, the same way that we've talked about in other contexts. So.
Federal agency power, revisitation of Chevron. As you regular listeners will know, we have three branches of government, but we also have an administrative branch of government, or an administrative collection of agencies, which is known as the headless fourth branch of government. In the 1930s and 40s, a series of cases involving the so-called non-delegation doctrine were decided, and efforts were made to curb the authority of of regulators to come up with rules that have the practical effect of laws. The Chevron decision requires the courts to defer to agencies when agencies are interpreting ambiguous laws, and people have been fighting it as the clause of the deep state, and looking to claw back power from agencies to make laws, and to make to move the rulemaking function back into the lawmaking function of the courts. I don't know what to think of this one. I think Chevron loses here. I think Chevron rather wins here in another close decision, maybe 5-4, 6-3. The liberal wing will want to keep Chevron. I think Roberts will want to keep it for court institutional credibility. And then, I don't know where they're going to go for that fifth vote, but I'm predicting a 5-4 vote upholding Chevron.
Oh man, I'm hoping you're wrong. And I have to work in this framework nearly every day, as you know, and things right now have just gotten to the point where those making reasonable interpretations of laws are not necessarily making objectively reasonable interpretations, and yet still getting the benefit of the institution and the influence that agency or institution has to hide behind it. I do think that Chevron has outgrown its use and needs to be reformed. So I'm hoping you're wrong. I'm hoping that Chevron, they just sort of slowly turn the machine off on that one.
We'll find out. And I think we'll find out all this week here on Law and Legitimacy. So look, we've talked our way through a half hour of your life. AMF Yo-Yos, we're back. Mike, where do people find us?
You can find us right here on the red platform at LawPod Daily, on the black platform at LawPod Daily, and over on the green platform at Law and Legitimacy. We'll be here every day this week as it currently sits. And then I think next week is the 4th of July. So Norm will talk scheduling for that. But by and large, you know where to get us. You can also get us on Locals. I've kind of dusted off Locals as a way to communicate with everybody about, show rescheduling, stuff like that. And also post anything that we talk about here. If there's some sort of PDF or something that I can upload to make it easier on our viewers to read and do the diligence themselves, in the spirit of Law and Legitimacy and what we complain about with other parties, try to at least do that for you guys. So over there on Locals, Law and Legitimacy. You can also find us on Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. And if you're still here and you haven't liked and subscribed, what are you doing? Anyway, hit that like button, hit the subscribe button. We appreciate you. Norm, happy Monday.
Happy Monday, Mike.
See you, everybody.